Yes, Mr. Searchlight.
May it please my ladies and my lord, can I thank the court for allowing these submissions of written and oral from Reunite, and Miss Chalabi at Reunite is sitting behind me along with the solicitors, and my learned junior. I won't take up time except to say I will endeavour to be less than the half hour allowed. And it shouldn't be thought that the number of people now in the front row indicates an ambition to double the submissions that the court will hear after me. I'm assured that's not so. The Reunite respects and respectfully agrees with the appropriateness of taking what is quite a deeply unsatisfactory situation to the Rules Committee, to the President, for a long look, which has an administrative product as distinct from a product in a judgment. But we do gently, my ladies and my lords, say this. That had been the recommendation of Mr. Justice Baker. That was, I think, 13 years ago, and not a lot happened. And so it may be that at the lowest there will be an interim between the emergence of a judgment from these appeals and the fulfilment of any work done by a committee. And it might be that the court would at least consider making some observations about that interim. But I'm not going to try to be artificial about it and make backdoor detailed submissions. I won't do that. But I will say a few things, if I may.
Certainly, that would be most helpful.
And the first, my ladies and my lords, very much from Reunite's point of view, and I do observe this, there's been a remarkable commonality between the content and thrust of the written submissions of your two interveners. The Reunite submissions, which go to similar authorities, not cited by other parties, and the ALC, that there's a commonality there, and our submissions slightly antedated those of the ALC, their submissions orally antedated mine. I obviously am not going to repeat, but from Reunite's point of view, perhaps one of the explanations for the very curious way that the practice of having solicitor guardians has developed is the nature of these proceedings. They're summary proceedings, they are intended to be dealt with rapidly, and the input of CAFCAS has historically been a relatively limited one to wishes and feelings reports and reports on objections, both fairly rigidly controlled by careful final hearing directions. And child representation has been the exception, but then my ladies and my lord know all that. The importation of what is fundamentally private law free enterprise representation for children is something which historically has been highly controversial in these cases. And I don't necessarily mean legally controversial. It's been controversial because these are private law proceedings, although they've got a slight public law international aspect to them, in which there is often a very high degree of adversariality between deeply engaged parents, comparable perhaps only to the close cousin of abduction proceedings, that is relocation proceedings, but with an intensity brought on by the urgency and sometimes the florid nature of the factual matrix. And so where there is a belief, which may be right or may be wrong, that it is one of the combatant parties who has been responsible for bringing about a situation in which the child is represented by a private solicitor without reference to Kafkas, and often until the application is made without the position being heralded with the court at all, or indeed with the other party, that gets matters off to a bad start. Now that's not something which Reunite seeks to elide with the facts of either of these appeals, and I remind myself and my ladies and my lord that it is none of Reunite's business to advocate for either of the parties in either of these appeals or for any particular outcome. But what it means is that for various reasons, a ready-made solution to a problem which is said to be acute tends to be served up at a hearing to a judge and not necessarily at the first hearing, because however desirable it might be that these matters are resolved at the first pre-trial directions hearing, quite often, as is apparent of course in the appeal against Mrs. Justice Theis, the fact emerges very, very, very much later. And we say that however desirable it is to reach the point of decision as early as possible, there will be cases where inevitably the matter is only reached at a late stage. It's messy, it's unsatisfactory, and so, with great respect, is the way these things are dealt with, which is not a criticism of parties, it's not a criticism of persons like Mr. Netto or Ms. Broadley, and it's certainly not a criticism of the judges who have to field the situations when they come about. But it's simply not satisfactory. Reunite reflects that for the reasons which are outlined in our submissions and in the ALC's submissions, there will be children who positively need and must have representation. How should it be achieved? We have looked in our written submissions at the history, as did my learned friend Miss Foxall in her oral submissions. We don't take up the court's time going through it again. We make this observation that in the case of LC in the Supreme Court, where Lord Wilson made remarks at paragraph 55 of his judgment, I don't seek to take the court to them now, it might be said that they are rather tentative and perhaps more obiter observations than determination. And my Lord Justice Moylan made a remark about the depth of what was said in the Supreme Court yesterday. We've done a little research, and it looks as if the only submissions recorded on the point are to be found on page 163 of the bundle. I'm not sure they're very profound or very good submissions. I'm allowed to say that.
You made yours.
And I'm afraid I had to be reminded that I made them. But to save the court's time, but not necessarily my blushes, the short rendition of them at letter H has me saying, however, in Hague Convention proceedings, no child is able to instruct a solicitor directly. In any event, even if a child can act without a children's guardian, and here are the words perhaps are interesting, the court remains able to make the ultimate decision as to whether a particular child has the necessary understanding to instruct a solicitor directly. It is highly questionable at the very least whether L&A are in fact able to give direct instructions in relation to the proceedings. At all events, all children are required to act with the benefit of a children's guardian. And we believe it's on that situation that Lord Wilson launched into his words, and in particular the words at paragraph 55, part of which are conjectural as to what might have happened. But this was, I remind myself an absolutely classic, highly adversarial case in which there was more or less trench warfare, into which the children were pitched with some views and some representation. That we do commend, as do many, the case of Ciccone and Ritchie. And if one is thinking about an interim approach as to what a cautious court, cautious I think was the MacDonald word, a cautious court might do until the Rules Committee has come up with something better. There was a case of a child, and I use that word because it's technically correct, who was knocking on the door of the upper age limit for the 1980 Hague Convention. Was unquestionably competent, but where there was a hot dispute, notably from Mr. Williams, as he then was, with the mother, as to whether this was all a put-up job. And the result was representation. Mr. Justice MacDonald, having made the observation, which we repeat to my ladies and my lord now, that of course, in circumstances like that, it's likely that a child needs representation, and needs representation where, my word's not his, the gloves are off, that the case will be forcefully put, we might say, on a solicitor and own client basis in adversarial proceedings. And I know that my lady and my lord have tried many Hague Convention cases at first instance, know how adversarial they can be. But there are other classes of children proceedings in which, where children are represented, they require to be treated as fully engaged parties. So there's no novelty in that. But Mr. Justice MacDonald was keen that there should be, as a safeguard and to inform the court, a welfare backup. And so he didn't simply say Kafkas stays in, he commissioned a Kafkas report, and that report was duly prepared. I should say that of course it was I who appeared for the child in that case, and in that case we were instructed by Ms. Ray and Miss Broadley. I say that as a disclaimer. But we also know in that case that there wasn't ultimately a judgment on the outcome because the mother decided to withdraw. And so Ciccone and Ritchie number 2 is the report of how Mr. Justice MacDonald dealt with the withdrawal application. So in that sense, the story is incomplete. But if the court looks at the present book, and if the court looks at the Kafkas first recommendation in the practice guide, though not in the rules, and I know the court's been through all this, won't be assisted by me doing the same. One way to approach it is that if a court feels persuaded that a child should be represented, which is exceptional, that perhaps as a matter of pragmatism, as much as anything else, it should be a private solicitor who does the job. That if there is a welfare element engaged, and in many cases the authenticity of the child's views will be an issue, then keeping Kafkas in and commissioning a report may be entirely consistent with a relatively speedy dispatch of the case. And we suggest that that might be a helpful approach. My ladies and my lords, we draw attention to some of the points which we provided on paper. One in particular, which might be of assistance to read if the court has the time, but for the Rules Committee in any event, is that we were, and all credit to Mr. Langford for this, able to research and find guidelines in Australia and the USA on how they deal with exactly this situation. And in one of them, at least, there is a bifurcation. There are two kinds of advocate. And really, in conclusion, I think, we draw the court's attention in possibly a more homely way than any of the others have done, to the problem which the present situation brings about. When I was given the relatively rudimentary training which there was in those days to come to the bar, but the same, I'm relieved to say, for Mr. Langford, some 35 years later, I was told that you do not give your opinions on things. You never say, I think, because if you do,
I submit.
The county court judge will say, what you think, Mr. Setright, is of no interest to me. It's not a question of admissibility and inadmissibility. It's a question of what comes properly from an advocate. Solicitors, of course, provide the court with evidence and argument on behalf of their clients, and they should do so fearlessly and vigorously. And my Lord Justice Moylan's comment about the use of an adjective has been taken on board by us. Vehement, expressed something vehemently. We don't wish, as we unite, to get involved deeply into the observations about admissibility and inadmissibility, but we wonder whether it's helpful to think about it in terms of what comes from a solicitor guardian in these terms. It's more likely that what is said will be received by the court, something which is self-evidently unhelpful and lacking in weight is likely to be disregarded or to be given marginal weight. It's more a question of finding some evidence that the court can rely on where there is a matter that is of importance to the resolution of a case. But my ladies and my lords, I said there would be a homely analogy, apart from the education of young members of the bar and what not to say, and it might be this.
That was giving evidence.
Well, I myself am often an object lesson,
Still an anecdote.
CLC, in what not to do. But suppose that one has a solicitor approached by a child, and that child is a 14-and-a-half-year-old who is outwardly competent, and we know that competence is something which, at present, and it's not up for grabs in this hearing at all, a solicitor is required to form judgments on, and if necessary, justify those judgments. It's hard to see the system working very well if that is not so. And so the child, outwardly Gillick competent, comes to the solicitor and says, here is a piece of paper prepared for me by my mother. This says what she wants me to say. And she said, give it to you. And this is what I want you to say. Here it is. What does the solicitor do? If the solicitor was a Kafka's guardian, she would say, thank you very much, probably ask some questions, probably turn it over and say, yes, but what do you want me to say and why do you want me to say it? But at the end, there would be a report in which that conversation would almost certainly be placed as an annex to the assessment before the judge and the other parties. And they would draw their own conclusion. The Kafka's officer's conclusion, which might be that there was quite a lot of pressure and inducement there, would also be in the assessment. What does the solicitor guardian do? Is the solicitor guardian bound to disclose the document and the fact of the conversation, or is the solicitor guardian bound by ordinary professional client rules in which case that is a confidential discussion. And what does the solicitor do? The solicitor may well turn the document over and say to the child, hang on a moment, I'm representing you, I want to know what you want. But she, the solicitor, is very much left to her own devices there. Now that's not these cases, but it is perhaps an extreme example of a problem that may occur, including a problem of reporting and accountability. We know that if a matter of child welfare which goes to safety emerges, then there's an obligation to a solicitor to report it, even against interest. But this isn't perhaps quite there. It's an exemplar of the problems that can occur, which we've referred to, which the ALC have referred to, and which are unresolved, even if they don't necessarily impinge particularly on these appeals. So, having said all that, we would like to see the system work, reunites in favour of pragmatism and in favour of fairness, but of fairness to children above all. And sometimes we observe a child may actually be prejudiced if she does not have the benefit of a proper welfare input to back up the enthusiastic submissions of the solicitor guardian. We endorse the suggestion that it should go to the Rules Committee. I've hurried it, but only to the extent of undercutting by 5 minutes. Can I briefly turn to those behind me?
Of course.
And of course, ask my ladies and my lords whether there's anything arising.
No, thank you very much indeed, Mrs. Setchell. Mr. Turner, anything in reply?
Yes, please. First of all, has the court yet managed to get hold of the approved version of the note of judgment?
I don't think we've tried.
I sent it through to my Lord's clerk this morning.
I actually thought we already had it.
Ah,
And it was just which one we were going to work from, because they were different paragraphs and would work from the previous one. So we weren't changing. But so I don't think you need to worry about that.
right. What I wanted to do was to just look at the position as it stands at the moment, because it's all very well saying, yes, clearly desirable that somebody looks at this in the round, taking account of views and problems that can be highlighted by all different parties and entities that have a legitimate interest in these matters, but that's not going to solve the immediate cases.
Well, we were going to decide the appeals, Mr. Turner.
Oh yes, I understand that, but
I don't even need to worry about that.
I didn't think the court was going to put that off. But
I mean, it was shortened judgment writing time.
it's the principles and the law which do exist at the moment that I wanted to just summarise as they've now come out, or as I submit they are taking on board and addressing some of the points that have been raised by my learned friends. And I do it in fairly bullet point form. First, as to children instructing solicitors for themselves, and the suggestion by Miss Kirby that there should be some prohibition on solicitors seeing a child unless both parents are either aware or involved. What we say about that is that the law stands at the moment, and as practice stands at the moment, professional practice, every Gillick competent child is entitled to instruct or seek advice from a solicitor without interference from others, or indeed knowledge of others. And it's for the solicitor at that stage to decide whether the child has the appropriate degree of competence to give instructions. In the sort of situation that Mr. Setwright has just canvassed, of course one step a solicitor might take is to say, well no, if you're requiring me to put forward this information for the court in due course, but not tell them where it's come from, I can't act for you, I'm afraid, in the way, because solicitors, whether they become solicitor guardians or not, have certain professional duties as well. Anyway, the idea of both parents or all parties with parental responsibility being involved would just simply not work in terms of being involved with a solicitor at the outset. So then there's the question of the, as it were, surreptitious pointing of a child to a particular solicitor by a party. And it's a matter for individual solicitors or matter for the professional rules as to how solicitors deal with one parent instigating the contact between that solicitor and a child. And it will also be for the individual solicitor to decide how transparent to be about that. And of course, we'll have to take the child's instructions in relation to that as well. But there will often, in many situations, be absolutely nothing wrong with one parent making inquiries amongst other professionals and saying, who would you recommend to represent or see a child in the dispute I have going on with the other parent? And the solicitor who takes on the child and knows how the child, isn't able to be the solicitor, will want to know how the child has come to see him or her. The solicitor will have to bear in mind client confidentiality, but will also have to advise his or her client that that's a matter that's bound to be probed in due course if the matter goes to litigation. How did it come about that you saw me? If there's an application for a child to become a party, it's something that's always probed. How did you come to get a solicitor? And that's not anything probing as to professional privilege. It's a matter of fact. And depending on the particular circumstances, that fact as to how the child came upon the solicitor or came to instruct the solicitor may or may not be relevant to first whether the child is then joined, because inquiries may be made of that before joinder, may be relevant to whether then the solicitor is appointed as a solicitor guardian, and it may be relevant to the weight which is given to the expressed wishes and feelings of the child, insofar as those are put before the court by the child's solicitor. There's no one-size-fits-all. That's the problem. So it's going to be very difficult to lay down any strict guidance on the matter. But what we do know is that solicitors have been acting for children who become parties in Hague Convention cases, certainly since Ray D in the House of Lords. Solicitors separately instructed to represent a child. And we know that also since Ray D in the House of Lords, solicitors who were instructed by a child have been providing evidence as to, first of all, the child's competence, and secondly, as to the child's wishes and feelings or objections in relation to Hague Convention cases. And we know that because we see it from the judgment of the speech of Baroness Hale in Ray D. We see that there was material about that from a Kafkas officer, and we see that there was material about that, including what looks like, just from reading the judgment of Baroness Hale, opinion evidence from the solicitor who was representing the child at that time. So since at least then it's been accepted that solicitors can represent a child. Secondly, that solicitors can provide evidence on behalf of a child. And thirdly, that solicitors' evidence on behalf of the child can give opinion. One has to bear in mind the point as to why a solicitor should be giving evidence on behalf of a child. And the point is so that the child's voice is heard. It's interesting to bear in mind that one of the other routes that was, that was identified by Baroness Hale in Re D for the child's voice being heard was the child giving evidence itself to the court. And her ladyship pointed out that that's done in lots of other countries, not necessarily giving evidence to the court, but seeing the judge. And the subsequent case of KP, we know that there are problems with that being done. But if the child sees the judge will then have the benefit of seeing the vehemence or otherwise, or the intensity or otherwise, the genuineness or otherwise, with which the child expresses its views. If the child isn't to give evidence itself, that someone else is to stand in the child's shoes, then surely that someone has got to get over to the court those matters that the child would want to get over if the child itself were giving evidence. And of course, it's said by some, said by Miss Kirby, well, solicitor guardians are not qualified to judge these things about wishes and feelings and how intense they are and all the rest of it. Well, one could say nor judges, but in that situation canvassed by Baroness Hale, one of the alternatives would be for a judge to see a child and form conclusions. So if the judge isn't going to do it themselves, they need somebody else to tell them.
Well, Mr. Turner, we are, so far as judges seeing children, we're very clear, aren't we, that judges must not get evidence from children.
Well, no, that's the result of KP.
So that's ruled out.
Yes, but if it was thought and said, as it was, that, well, that's one of the other routes for which it should be done, can be done, the whole point is that you need an alternative so the court can be put in the same position as if the court itself was able to see the child. And the court, if the court saw the child giving evidence, the court would have perceptions as to the child's stance. Lord Justice Moylan has said that in relation to the example he gave of the vehemence of the child's expressed wishes. Well, that's a perception. In a sense, it's whether one calls it an opinion or whether it's a perception, it's probably the same thing. But the court needs to have some way of gauging that. So if the solicitor is permitted to give evidence, then the solicitor must at the very least be permitted to give perceptions in addition to pure recitation of the child said to me ABC 1, 2, 3. As I say, solicitors without being made guardians were giving evidence on behalf of children, certainly as from Re D times, and the only change in that practice came about when it was spotted in the case before Mr. Justice Baker that the rules require a child who becomes a party in a Hague case to have a guardian. Now, we've looked at this, what's said to be the curiosity in rules 16.4, 16.6 as to why in some cases, in some situations, a child is required to have a guardian and in others not. We don't know what, if any, consideration was given to the rule by the rule committee to that when the rule was formulated. Because clearly somebody thought at some stage there is a reason for a difference between the situations. I can't begin to think what the difference could be between, for example, a wardship case, a wardship abduction case, and a Hague Convention case. But somebody must have thought about it, surely. If a child is not required to have a guardian when the child becomes a party, will the solicitor still be able to give evidence of any sort? Or,
Mr. Turner, I hesitate to interrupt, but first of all, this is reply.
yes,
And also, I think we'd all be interested to know how you relate this to the actual grounds of your appeal.
I'm going to do that, but I wanted to set out what seems to be the situation now. The important point is the purpose of evidence being given is so that the court has evidence that reflects what the child would say if the child was giving evidence before the court. My point is that we can see that it's permissible for a solicitor guardian, or indeed even a solicitor, in the days before solicitors, it was realised there had to be a guardian as well, could give evidence, and they were giving opinion evidence. Even Mr. Justice Baker's case, there was opinion evidence from Miss Hanson. So, what is the prohibition on that? Well, there's no prohibition on that because it's permissible under Section 3, subsection 2 of Section 3 of the Civil Evidence Act of 1972. That's how one justifies opinion evidence as to perceptions. The child said this vehemently. And if we look at the judgment in our case at paragraph 42, we look at the, well no, let me go to paragraph 54. The judge there seems to have been concerned. So it's important to be strict about the difference of giving wishes and feelings and giving his opinion. Yet he proceeded to give his opinion. His over-exuberance was evident in the description of the child being caught between the parents like a ribbon. Well, that was what the child himself was reported as having said to Mr. Netto. He was like a ribbon on a tug-of-war rope with parents pulling on each side. And Mr. Netto had said, that was one of the most striking things a young person has ever said to me. Well, first of all, that's not, I submit, opinion. It's a statement of fact about which Mr. Netto could be cross-examined if necessary. And even if it is an opinion, it's an opinion related to what the young man was telling Mr. Netto. So it would be admissible under Section 3, subsection 2. But there seems to be perhaps some failure on the part of the judge to distinguish between opinion evidence, which we submit as admissible from Mr. Netto, and expert evidence, which wouldn't be admissible. In paragraph 50, at the end of paragraph 50, and I'm using the approved version, one can test this proposition very easily. Would Mr. Netto be eligible to be instructed as an expert to assess children who are not his client and give his opinion on the influence? Mere expression of the question answers it. It borders on the absurd. Such a Part 25 application would not be considered by the court for a moment. And the consequence of all this was paragraph 56 in the approved version, that although, as Mr. Gratian says, oh well, whatever all the law may be about solicitors giving evidence and giving opinion evidence, the judge permitted it to be given here, and it was just a question of weight. But when we look at the weight, we find the judge saying, the evidence having been admitted, my task is to assess its weight. In my judgment, it's negligible. But why is it negligible? If he's reporting what the child says and expressing not expert evidence in relation to that, but expressing perceptions in relation to that, particularly if he has a better or an increased standpoint from that which the CAFCAS officer had, then why should it be negligible? The fact that he's said those sorts of things that the child has told him. Well, first of all, the judge was not simply excluding Mr. Netto's opinions, as it were, giving them negligible evidence, negligible weight. The judge was also excluding or giving negligible weight to the underlying recital of factual matters, albeit Mr. Netto was in a better position in many ways than the CAFCAS officer to provide that information, the fuller picture, as full a picture as possible. We know that Lord Wilson in Ray LC envisaged solicitor guardians providing a report to the court. Section 3.2 permits evidence once someone is a witness to include opinion evidence. So, in effect, what the judge was doing there was inhibiting the more versatile approach, was saying that, yes, although Mr. Netto had seen the child for far longer than the CAFCAS officer, even though he'd built up a rapport with the child, even though there was nothing in direct conflict between what Mr. Netto said and what the CAFCAS officer said, I'm going to give negligible weight to it. And that's why we say the judge was stifling the voice of the child, which should have been put before the court as fully as possible. And although Mr. Gratian says, well, you say the judge should have admitted evidence from Mr. Netto and admitted opinion evidence, well, that's exactly what he did. It was just the weight he gave to it. But that's rather too simplistic an analysis if one looks at things like paragraph 41, paragraph 50, paragraph 54, and paragraph 56. A few other points, if I may. Mr. Gratian made some point about Mr. Netto would he have behaved differently if he'd seen the texts between father and the father sent the child. Of course, Mr. Netto had seen those, certainly before he made his second witness statement, because they were annexed to the mother's witness statement, which he discussed with the child. We say Mr. Netto was in not simply as good a position as the CAFCAS officer, but in a better position. And the judge had the benefit of seeing the broader position from Mr. Netto. So the child deserves to have his voice put before the court properly once this confusion has been sorted out, which is why we say there should be a rehearing. It was suggested that in the skeleton argument on behalf of the child, we had said that the Mr. Justice Mostyn case about Gillick competent children provided an analogy in that children's voices should effectively always take precedence. That's not what was said in our skeleton argument. If you look at paragraph 75 of our skeleton argument, what it actually says is that there isn't a direct analogy between the situation Mr. Justice Mostyn was looking at there and a Hague Convention case, but it does help to show the importance of a child's objections in the balancing process. But of course here the evidence about the fullness of the child's objections was, if I can put it this way, cut off at the knees. And Mr. Justice Mostyn himself, in paragraph 24 of that case, makes it clear that what he's saying there doesn't apply to Hague Convention cases. So that isn't what we'd said at all about that. I referred yesterday to the S&S case, the Mr. Justice Peter Jackson as he was, in the context of my argument that a child's views can be authentic or genuine, as I would suggest them, and strongly held and genuinely held and important in that sense, even if they have resulted from influence of a parent, even malign influence from a parent. And the lady asked me yesterday which paragraphs of the judgment of Mr. Justice Peter Jackson you should look at, and I'm grateful to Mr. Bennett for having gone through that. And
Tab number?
Tab 27. Should I just give you the paragraph numbers within tab 27? It's paragraph 10. Paragraph 19. Paragraphs 22 to 23, which effectively say the judge's conclusion was the strength of the children's wishes and feelings, albeit they'd come about in the way one knows, made relocation the only viable option there. Yes, and I think that was all of them. So those two factors, we say the judge, regarding or conflating opinion evidence with expert evidence in the way he did, saying, look, you'd never get permission under Part 25 to give this evidence, we accept that. And discounting the factual evidence as well on the basis that it had been influenced without hearing or taking account of the opinion evidence or the underlying factual evidence about that, leaves the court with a flawed decision that should be retaken after these matters have been clarified to the extent that I've suggested. So, lady, those are my submissions in reply.
Okay. Thank you very much, Mr. Laing. Yes, Ms. Kerr.
My lady, may I start by answering the question that my lady asked this morning about whether I had addressed the court on weight and admissibility. I knew I hadn't addressed her on admissibility, and I doubted I had on weight, and I was right. We checked the note, and I didn't address her on either of those points. One of the reasons that the issue of opinion, evidence, etc., didn't arise at that hearing was because in Hague cases, except in exceptional circumstances, the court doesn't make findings of fact. And for our part, we didn't expect any findings of fact to be made at that hearing. The actual substantial hearing was half a day. We had finished by 2 o'clock on day 2. We started at 10:30 from what I can recall. And I was responding to the defences put forward on behalf of X and supported by the mother, the burden of proof being on the child to establish the 2 defences she was relying on, 13B and objections. So the only circumstances, as the court knows, in which usually there are findings of fact are where there is oral evidence, and in Hague cases, oral evidence is generally reserved for consent and acquiescence cases where there's a difference of evidence between the parents. That wasn't the case here, and when we were looking at Miss Broadley's 2 statements, they had already been admitted. The first one on the 8th of March when Miss Broadley made her ex parte application, and the other before the directions hearing on the 16th of March. So they were already admitted into evidence in support of Miss Broadley's 2 applications on behalf of the child. They had been relied on by the court to set aside the original judgment, and the court clearly believed that there had been a change of circumstances. So we had the option, the option was there to cross-examine Miss Broadley, but we didn't cross-examine her because we didn't anticipate there would be findings of fact about expressions of opinion contained within those statements. So we could have cross-examined her about the inaccuracy of the facts that she was reporting as reported by X to her, as opposed to what was in the evidence before the court. We could have cross-examined her about the irrationality of X's position, saying she was scared and her mother couldn't keep her safe, because we knew that her mother had kept her safe for 2 years post-separation, and indeed when in London. And Miss Broadley wouldn't have been in a position to say, for example, whether it was true or not that the relationship between the mother and X had completely collapsed. That was the case that X and the mother was running. They were each running. But we couldn't cross-examine Miss Broadley about that because she wouldn't be in a position to know that or not, because she couldn't have assessed that situation by speaking as a solicitor to her client. So we didn't cross-examine her, but we, as I say, didn't expect findings of fact to be made. And the reason we didn't expect it was because it would be inappropriate for the court to rely on the evidence of a lawyer, which is what Miss Broadley was. And it was for the reason that the missing evidence was from Kafkas. So our grounds 1 and 2 of our appeal relate to that refusal to grant the adjournment that we asked for, to fill in the evidential gap that the court was in at the start of the hearing in May. And I took the court yesterday to the 4 areas that we identified that Kafkas would have reported on had Mrs. Justice Theis given the adjournment that we asked for. By refusing that adjournment, Mrs. Justice Theis was missing the expert evidence that in April she had recognised that she would need in that recital about if separation was contemplated, then she would need the Kafkas evidence. And she was right about that. But as a matter of logic, when the application for adjournment was made for separation, then the evidence was still necessary. But Mrs. Justice Theis decided that now time had passed and the evidence was no longer necessary. And we say she was wrong about that. She was still missing that welfare expert evidence, that a gap that couldn't be filled and shouldn't have been filled by Miss Broadley's opinions and reports of what her client was saying to her. So that's our grounds 1 and 2 of our appeal, is that Mrs. Justice Theis erred in not getting the evidence that she recognised she needed in April, but now was saying she didn't need. And I refer to Kafkas's email again. Miss Doyle said one of the things the court might want them to do on an addendum report was to comment on the authenticity of the views being expressed by X. Miss Doyle recognised that that's something that the solicitor couldn't do because she doesn't have the appropriate qualifications to do it. And equally, Miss Broadley was not in a position to give the evidence that the court needed on welfare. So those are 2 pieces of evidence that were as relevant as they could be to Mrs. Justice Theis's exercise of discretion. And that's why we said we needed an adjournment. The court needed that evidence before proceeding. But what Mrs. Justice Theis went on to do is that she, in effect, made findings of fact based on submissions. And that was neither expected nor fair. And we say makes good our application to overturn the decision that she reached. Examples of the welfare element that Mrs. Justice Theis had to look at in the exercise of her discretion were, the mother's case was that she had had a very close relationship with X up until X allegedly overheard a conversation where the mother says she was crying on the phone, that the mother was crying on the phone. Well, Miss Broadley didn't know whether that was true or not, and Mrs. Justice Theis didn't know whether it was true or not. Mrs. Justice Theis accepted what X reported through Miss Broadley as being facts, and we see that in her judgment at paragraphs 64.2 on PDF 119.
(64.2).
64. I'll just pull it up myself. Yes, 64.2 at the end of paragraph 2, the very end of paragraph 119.
Well, starting at the beginning of paragraph 2, the judge there is dealing with a submission made on behalf of the father that to conclude that the mother had orchestrated recent events.
Yes.
So you were there asking the judge to reach a conclusion as to whether or not, would you describe that as a finding of fact? Because that was a submission you were making.
Yes.
That the judge, a conclusion the judge should reach. Is that a finding?
Well, what I was saying was that we couldn't put a positive case that the mother had done what we suspected she had done because nobody was there.
But you
to
were putting
witness it.
before the judge an issue she had to address. The
Yes.
issue being, namely, should the judge conclude, or should the judge decide that the mother had orchestrated events or not? So I just puzzled by your finding of facts. If you're dealing with a child's objections, one of the issues the court will necessarily have to determine is what weight to put on those views. And one of the issues relevant to what weight will be, are they, have they been influenced? Have they? So I mean, I just don't understand this point you're making about, just speaking for myself, about findings of fact.
This point is about reliance on Miss Broadley's expert opinion. I'm not speaking here about. I have made the point that there were findings of fact. The finding that I am referring to in this paragraph is at the end of that paragraph, where she says she's carefully considered whether the mother might have orchestrated it. But then she goes on to say X's own account of the impact on her and Miss Broadley's experience in dealing with these cases, together with her assessment that X's views are her own, and they are clear, strong and compelling, she accepts.
Well,
So-
that's an issue you would ask the judge to address.
Well, my lord, we didn't have the evidence that the court needed.
But no, that's not the point. Sorry, with respect. If you had asked the judge to address it, how would you submit she should have addressed it differently from how it's addressed in this paragraph?
Well, we were saying that as far as we didn't expect any findings of fact. We didn't expect any findings of fact. But what we were saying was that in the exercise of her discretion, she couldn't decide that it wasn't orchestrated because it was impossible to say. But what she did was she accepted that, or she found that it wasn't orchestrated. And she found that everything that X had done was done off her own bat, with no influence from the mother. So we were saying she didn't have the evidence to go that far because the only evidence she relied on was Miss Broadley's evidence. And Miss Broadley wasn't a person who was qualified to say how authentic or not X's views were. Because that was the realm of Kafka's. They had said in January that her views were authentic, but this was May, and the process had changed significantly.
Sorry, I thought you said that you hadn't made submissions about admissibility or weight.
Yes, I haven't.
So what submission are you now saying you did make? That this was not evidence?
That the court didn't know why X was saying what she was saying, and that the only way to have found that out, obviously, was by Kafka's going to see her again, which we had asked for, and it had been refused. But what we didn't expect to happen was that in the absence of Kafka's, that the court would exercise its discretion to make findings that the views were genuine, uninfluenced by the mother, and to use it as the hook on which to exercise discretion not to return. That was not foreseen, because we couldn't have, and certainly didn't believe that the judge would make a finding of fact, which is what she did. She made a finding of fact based on Miss Broadley's evidence that this was genuine distress being demonstrated by X over a period of weeks. That wasn't expected and isn't usual, because there was a whole conversation with Mrs. Justice Theis on day one about welfare, and she pointed out that the exercise of discretion was sounding like a welfare exercise, and we agreed that it was a welfare exercise. But at the same time, she then went on to say that she wouldn't allow the adjournment to get the expert evidence on welfare that one would usually have in a Kafka's, in a Hague case.
Can I just take you back then from that to submission you made a moment ago about Ms. Doyle's letter? And I think what you said to us, and please correct me if I misunderstood, what you said was that Ms. Doyle had said in her letter that she would anticipate fast what she'd have to do would be to assess authenticity, and that she would have to do that because the solicitor guardian would not be an appropriate person to do that, would not be the right person to do that. Now, I've turned up the letter, and
yes,
that's certainly not my reading of the letter.
The second part, well, thank you for turning up the letter. The second part of what you've just summarised is me adding on, and we weren't expecting.
But even if that's the case, that's still nothing. What Miss Doyle said is, I request that these issues are considered by the court and the parties when determining whether a further report from Kafka's is required. If there remains a need for a Kafka's report, there may be consideration given to assessing the views of the older child only, and perhaps a limited exercise to reviewing the statement filed by the solicitor guardian and considering whether their views accord with those that were provided to CAFCAS, and whether there are any observations made by the family court advisor regarding the authenticity that the court may wish to consider.
Yes, sorry, can your ladyship just give me the page number for that? I'm
279.
Thank you.
So my reading of that letter was that Ms. Doyle was saying, if it's necessary, and further up we know she was saying, I'm not sure it will be necessary because you've got the views of the guardian, I would think about talking to the girl and seeing if my views are the same as that of the guardian.
Yes, the authenticity point is...
That's not saying, because the guardian... we have to look at this again because the guardian's not qualified to look at it.
No, I'm sorry, I wasn't suggesting that CAFCAS had said that. They clearly didn't know anything about the case. They're talking in theory about what a court reporting officer could add to the picture now when there was a solicitor guardian. So my point, which I must not have made sufficiently accurately, is referring to this paragraph, where they are giving a menu if the court wants their further involvement as to what they would be able to do. And the point that I was trying to make was that one of the areas in which CAFCAS always comment in their reports in Hague Wishes and Feelings cases is the issue of coaching influence. And that is clearly what Ms. Doyle is referring to there. But so that was something that was missing when Mrs. Justice Theis made her decision in May, because matters had moved on significantly from when Miss Callahan had seen that had seen X in January. Because at that time, if you recall, X was saying she didn't want to see the judge, and she didn't want to, and Miss Callahan's view was she shouldn't be joined as a party. That was the 10th of January. So one of the areas that she has identified here is that a CAFCAS person would look again at in these new circumstances, I suggest, was the authenticity of the older child's views.
Is there anything else that you want to add?
Yes. I was just speaking about Mrs. Justice Theis's recognition of the significant welfare element with which she was dealing in the context of the exercise of her discretion in the new circumstances that she was faced with in May, as opposed to what had been there at the end of January. And she records in her judgment that she, you don't need to look at it for PDF 112, that she gave time for the father to consider whether he wanted to withdraw his application. And what she was suggesting was turning the Hague proceedings into a full welfare inquiry. And that's the extent to which she recognised that there were real live welfare issues which are not properly dealt with in a Hague case. So where we say she went wrong was that she sacrificed all of the welfare information that she needed in order to understandably finish the Hague case, because at the end of the day there were children who were waiting for an outcome, and she was understandably very keen to finish it. My client was very keen to finish it, but once it became clear that the mother and child wouldn't say definitively what they would do in the event of an order for separation, then that was when my client thought that there was no option but to adjourn so that there could be proper welfare evidence adduced before the court. And the three paragraphs where we say Miss Broadley stood in for a properly qualified expert were 64.3, 64.8. She found there hadn't been coaching. you see at the end of 119, we've just finished at 119, and then she goes on to say that Miss Broadley's statement is balanced and compelling, and the court has to be alive to the risks of the mother's influence, as was Miss Broadley, whose assessment that X was not being coached is accepted. So she accepts Miss Broadley on the issue of authenticity and coaching in a way that we say was not open to her, given the lack of appropriate expertise in Miss Broadley. Again, at the end of paragraph 3, she says, this is a summary process, and whilst there may be an element of X's view of the past regarding her schooling being viewed through the prism of her strongly held views now, the views X currently holds remain the reality for her. That is based on Miss Broadley's evidence only, and they need to be given considerable weight by the court, bearing in mind her age and maturity. That is something that Kafkas should properly have been looking at, and the court not relying on Miss Broadley for that. And then ground 5 is covered at the end of paragraph 5, where Mrs. Justice Theis says that the father doesn't demonstrate any recognition from X's perspective of the impact she reports such behaviour has had on her. We say that was not a comment open to Mrs. Justice Theis to make, given there were no findings of fact in relation to any abuse. And at subparagraph 8 at the end of 120, Mrs. Justice Theis says the court is very conscious of the points made by Ms. Kirby about the involvement of children in these cases. Each case is fact specific, and the court is alive to the risks of children becoming involved at the instigation of one parent or another. I am satisfied this is not one of those cases relying in particular on the evidence of Miss H and Miss Broadley. So again, she's relying on the evidence of a lawyer and the head teacher combined.
Sorry, which paragraph is that again?
It's subparagraph 8.
Oh, 8, yes.
And
yeah,
it's
okay.
at the top of 121.
Yes, thank you.
So she makes a finding there that the position that X has taken up is uninfluenced by the mother, and that she hasn't put her up to it. And again, we say absolutely not open to Mrs. Justice Theis to rely on Miss Broadley's evidence as a solicitor who was advocating a cause rather than a proper person. Briefly, we don't accept, as submitted by Mr. Hames, King's Counsel this morning, that Miss Broadley, what she did was a model of how it should be done for the sorts of reasons that I am now ventilating, that it led Mrs. Justice Theis into relying on a lawyer's submissions, because it's on instructions, but in effect, Miss Broadley is a lawyer and she's making submissions, and that's what she was doing in writing, and then through Miss Baker, making submissions as if she's an expert, when actually she is pursuing the agenda of her client in the way that she should, as a lawyer, but not as a child-focused person. It's also right that there was delay as a result of the slow process of Miss Broadley making her application. She first alerted my then solicitor, who's sitting in front of me on the 27th of February, that she was had been approached by the child, and then made an application ex parte without notice to anyone on the 8th of March, which was just 2 days before the return was to be effected. Father had bought flights, etc., and it led to further delay and anguish. The other thing that Miss Broadley does, which is perfectly fine as an advocate and as a lawyer, is that within her statement she uses the welfare evidence from January as a base and then builds on it. So it gets more legitimacy. Her opinion gets more legitimacy by starting from where the Kafkas report is. For example, competence not being coached. She agrees on the competence front. She then says, I broadly agree about some points, and then she goes on to build on that. So the fact that the child had not been coached according to Kafkas in January, Miss Broadley in her statement then uses that finding from January to build on why she says now the child isn't being coached, whereas that's not legitimate. Maybe legitimate as an advocacy point, but not as a child welfare point or an objective way of doing it. And there are examples within her statement, plenty, of where she goes beyond just an opinion.
You've taken us through all of those in your
Yes, and I'm not intending to. Mr. Turner just referred you to Section 3.2 of the Civil Evidence Act. That refers as an exception, firstly, only to perception, and secondly, to when a witness is called to give evidence. And Miss Broadley wasn't called to give evidence. She obviously, we're talking about written evidence. And just finally, I think in terms of the point of raising a new point on appeal that wasn't raised at first instance, if that's the way that it's formulated, that it's opinion evidence and that point wasn't raised at first instance. In Mr. Hames's skeleton, you have reference to Glatt and others, which is a High Court case referring to the exception that if it's a point of law, unless it causes unfairness, it can be raised and will usually be dealt with by the Court of Appeal. The relevant quote is in Mr. Hames's document. It didn't make its way into the authorities bundle, but it's at PDF 62, paragraph 41. And it's where the High Court judge refers to Lord Justice Nourse, saying that there's a discretion to exclude it, but generally it will be allowed unless it causes unfairness. And here, the reason we find ourselves in this position is we asked for the appropriate opinion evidence by way of an adjournment in Kafkas. It was opposed on behalf of the child and the mother that we get that expert evidence. And instead, the judge ended up, we say, leading herself into error by relying instead on solicitor evidence rather than getting the proper evidence. Thank you, Melanie.
Thank you very much, Ms. Kirby. Well, may I thank you, this cast of thousands, all very much indeed. Both the appeals, and also I'm very grateful, as always, for the intervention from ALC and Reunite. Their assistance is always most welcome. But of course, we are acutely conscious that valuable that contribution is. These two appeals relate to real families and real children, and it's those families with which we are, of course, primarily concerned. We're very grateful for all the work that's gone into the preparation of the appeals. We will now reserve our judgments, you won't be surprised to hear, and I can't, I'm afraid, tell you precisely when they will be handed down or sent out in draft, because we simply don't know how long it's going to take to prepare them. But we are conscious, of course, that these are families, that the children's lives are on hold effectively until these decisions are made, and so we will endeavour to have them as soon as practicable. You'll be sent drafts in the normal way. For typographical, grammatical and minor factual errors, please, not an opportunity to re-argue. And might I remind you, I think this might be mostly the handling of the juniors, to take note of the embargo on the top of the drafts, as they now are, and ensure that the court has sent proper lists of those people who are going to have access to the draft prior to the handing down. After that, I'd hope that all matters could be dealt in writing. If there's any outstanding matters, we'll deal with those on paper. Thank you. Mr. Hague.
May I just make a small plea on behalf of X? She starts at a new school on the 4th of September. She was held down a year, which is why she's changing a little bit later than her chronological age would suggest. I, of course, appreciate the many, many calls on this court's time, but I am instructed just to make that small plea. even if it were just to know that she
What
was
the answer is.
abstaining.
We will, of course, do our absolute best without making any promises.
Thank you ever so much, my lady. I'm very grateful. I'm sure X will be too.
Thank you all very much indeed.
What we're asking and reliable